Good morning.
Good morning, how are you?
So I've taken a look at the file. I took a look at it yesterday, and to my absolute surprise, I realized that there was no e-bundle available, and it was due to be filed on Monday, close of business on Monday, and up until close of business yesterday, nothing had been filed. Which makes my job very difficult because it means that I did not have any time to review anything before the CMC today. So I'm in the party's hands as to how you wish to do this. I'm hoping that the procedural timelines have been agreed, and the list of issues have been narrowed down. I've been in meetings since 9 o'clock this morning, so unfortunately, what was submitted yesterday, I didn't have a chance to look at this morning. So I'm in your hands, Mr. Bajamal, given that you act for the claimant, on how you wish to proceed. And Mr. Senanyaki, you can obviously provide your submissions and your viewpoints as and when necessary.
Thank you. Good morning. I would just like to clarify that we did file the bundle twice, and we received communication from the registry saying that it is not appearing on the portal, and we even took a screenshot when we made the upload, and for some reason the registry was not able to see it on the other end, and then we were asked to contact the technical support team, which we did. And then the technical support team told us that there is a problem from the court's end and the portal, and that's why the court is not able to see the bundle. So we did the uploading again yesterday, and we were then told that it's fine. But yeah, so there was no delay from our side, and we emailed the screenshots to the registry yesterday. With that said, I understand that, okay, we are where we are today, and it's unfortunate that you did not have a chance to review it. But in terms of how do we suggest to carry on today, I believe we can start with the case management order, because this is a document that I believe the defendant made some changes to it, and I've reviewed their changes, and I'm very much in agreement with the suggestions that they made. So I think we can progress well by starting with this document and then moving to the case memorandum. With the case memorandum, I do have some comments on some of the amendments that were made, but again, I don't see anything too major here that we cannot resolve today, hopefully.
Fantastic. Mr. Bajamal, out of curiosity, when did you upload the bundle yesterday?
My colleague is just sitting next to me.
It was before 3:30, around 3:30 p.m.
Around the second time round, we did it around 3:30 yesterday, after we were told that it was not appearing on the portal. And the first time round,
The first time was within the deadline on Monday, also around 2:30.
And the first time round was on Monday around 2:30 p.m.
Okay, so I'm hoping the registry team is taking note of this. For next time, if the parties can just please email the registry to let the registry know that the e-bundle's been uploaded. Was that done, Mr. Bajamal?
Yes, it was done, and there was something strange, because we did email the registry, and then we received an email yesterday saying that they didn't receive this, but we have it in our sent box delivered with no bouncing back. So
Okay.
I don't know why is that.
That's strange. So we've got Mr. Khan on the line, who's part of the IT team. So I'm hoping that he'll look into this for us to see what the problem was. Anyway, moving on from that, I'm not going to impose any filing fees, late filing fees, or anything like that. I think we should just try and get on with it. If the parties have come to some agreement as to the draft order, that's fantastic. Maybe you can take me, Mr. Bajamal. I'm going to switch my camera off so I can review the documents now. But I'll let you guide me through, and Mr. Senanyaki can say his piece as and when he needs to.
Thank you. Okay, so we'll start with the case management order. So the first part with regards to the production of documents. So I hope you're seeing the one that has the track changes. So you'll see here that the first part, which is now inserted in track change, production of documents. So we are in agreement with points 1 and 2 that to
Sorry,
carry
Mr.
out
Bajmal. Can you just take me to the document number, because
yes.
I can't seem to trace it immediately from the document that I have with me. Thank you.
Sure.
I wonder if Mr. Bajma is able to share his screen. Might be easier.
That might be easier, yeah, Mr. Bajmal, if you wouldn't mind
Yes, I
doing
can do
that.
that. Sure.
Thank you.
Can you see my screen?
Yes.
Yes, I can. Thank you.
Okay, so we so the first just the intro paragraph is agreed by us. So there's nothing to discuss there, and then we start with the production of documents. Again, we agree with the defendant's insertions at numbers 1 and 2. So as for the method of disclosure. So the date as well is fine for us.
One thing I will say about this case is I will be case managing it in detail. It's obviously a case that's been lagging for some time. It was registered way back in 2018. So I'm going to be quite strict with the deadlines that the parties have set. Obviously, as we go through the document, if I find that there are deadlines that are perhaps a bit late or, imposed with too much time, then I will probably provide my comments to say, let's try and truncate this and make it a little bit more efficient. But I've got no problem with the production of documents deadline. Is this something that the parties will realistically stick to?
Yes, for us, yes, this is realistic.
Yeah, we had suggested this date, Madam Minister.
Good, thank you. Sorry for interrupting you, Mr. Bechamel. You can proceed now. Thank you.
Thank you. So again, we agree with very much everything up to the end of paragraph 5. So these are the steps for the disclosure. Then we move on to the witness statements part. So with regards to witness statements, I just would like to point out that we do not have any witnesses other than, so we have one witness for which we have already submitted 2 witness statements, and we do not expect any further factual witnesses based on the evidence filed so far. So that's where we are. I think it'll be useful to hear from the defendant if they intend to submit any factual witness statements, and then maybe we can work it the other way around, and they can submit first, and then we can submit rebuttal witness statements if required.
if I may, Madam Registrar, I mean, it's quite strange for a party to file witness statements with their pleadings, and we certainly don't think that was procedurally appropriate. So any witness statement that was filed with any pleadings of the claimant, we object to, and our position is that it should be filed in the regular course, which is at the stage of filing witness statements. So I think there should be provision for filing witness statements. We do intend to, at this time, file witness statements. The claimant's witness statements should also be filed in view of the CMC order, I think.
If I may just comment briefly, I mean, I understand the defendant's position, but in terms of time management, given the fact that the defendant's already had a chance to, we are confirming today that we will be filing exactly the same 2 witness statements that we've already filed with our pleadings. So perhaps the timeline can be worked out on that basis. So rather than, because we don't need until the 30th of June to submit the same witness statements, so we can submit them earlier, and then the defendant can submit rebuttal evidence earlier as well.
Well, no. So the date for production or the request for documents is 30th of April, and we expect at least 2 months to pass between the production of documents and if there's any disputes for the court to get involved. So a 2-month gap is not unusual between requests for production of documents and filing of witness statements. And I'm in your hands, Registrar, but we just think that it's a reasonable period.
Can you give me some background as to the claim? Because again, that wasn't something that I've unfortunately read into, and I'd probably be able to make a better decision. So can we talk about the claim value, just a general overview of what the claim is about?
Yes.
20 minutes.
The claim, the value of the claim is around 20 million dirhams plus interest. The dispute is with regards to an investment that was made by the claimant into one of the Abraj group entities, and following the collapse of the Abraj group, the claimant made inquiries with the appointed liquidators with regards to trying to locate the investment, and then evidence was found suggesting that the investment was never made. Therefore, it is the claimant's position that Mr. Arif Naqvi is personally liable for it. The allegation that is being presented against Mr. Arif is that he personally solicited this investment from the claimant, and then on the other side, the allegation is that he personally also misappropriated the funds and gave instructions to staff to deal with the funds in a different way. So that's in a nutshell the dispute.
Thank you, Mr. Vegemel. Understood. I think the claim value is quite substantive. I completely hear you when you say that the witness statements are already prepared and you can submit them before the 30th of June. And you are, I think, very much free to do so, but you may, after production of documents, want to amend the witness statements. So I don't want to take that right away from you. So I think if we stick to the current deadlines, and I do appreciate the fact that you're trying to be proactive and obviously truncate this on the basis of what I said earlier, but I don't want to afford your client a lack of opportunity to amend the witness statements in the event something comes up in document production. So let's stick to those timelines. The 2 months is fine. Mr. Sanyaki, anything you've got to say?
No, that's fine. The other thing is, Madam Registrar, one thing you might want to be aware of is that my client is currently under house arrest, and he's challenging extradition proceedings, obviously on facts that are disputed. So that he's also under some difficulty in obviously having access to certain documents and all of that, and that's why I proposed this 2-month gap. So that's probably something that you should be aware of in the timeline situation.
Noted. Thank you.
Thank you. Perhaps this is a good time to raise this point. We do have an application to obtain the court's consent with regards to amending the claim form, and I think it would be good for us to cater for this within the timeline as well.
On that, Madam Registrar, in fact, I just want to say that we don't object to that application. However, in terms of RDC 18.12, the claimant should have sought input as to whether we agree to the amendments or not. No such efforts were done. They just made the application. So as long as there are no cost orders, we have no objection to the amendment application.
Does that mean or extend to the fact that you've got no objection to the amendments raised in the amended claim form?
That's correct, Registrar, except
Okay.
on the cost. Except on the cost.
Except on cost. Okay. Okay.
We are. That's. I think this is good. So we are able to agree today that we won't be pursuing any cost, so we can dispense with it on that basis.
That's fine.
Okay. So, Mr. Seniaki, anything you want to say about costs on the amendment application?
Like I said, Madam Registrar, it's just that we were not consulted on the amendments in terms of 18.12, for instance. Parties were supposed to agree on amendments, but the amendment was done in the, I believe, the particulars of claim without making a formal application, and we raised it in the defense that a formal application had not been made. And thereafter, we were not consulted on whether we agree to the amendment, and application notice was filed. No further correspondence occurred in between. So our position now is that we do agree to the amendment, which is an amendment in terms of the quantum of the claim, as long as there are no cost orders, because the procedure on seeking agreement was not followed.
I guess my question was more tailored towards, do you have cost submissions, or I'm very much happy to either, so we can either get the parties to sign or agree a consent order as to the amendment application, and we dispose of it that way, and there's no order as to costs.
Yeah.
Okay, fantastic. So why don't the parties execute a consent order to that effect? Otherwise, it can form part of this, or I can issue an order to say that that application is disposed of on the basis that the defendant does not object to the amendment application and there be no order as to cost. So either way, I'm happy with it. It's probably, given the consensual arrangement, I think it's probably more sensible for the parties to agree a consent order on the same and file that in court, and we dispose of the application that way.
I agree, Madam.
Agreed. Thank you.
Thank you.
Okay, so with that, then we move to the progress monitoring date. So we don't have a date listed at the moment. That's that. If we consider that the witness statements will be filed, or the response will be filed 14 days after the 30th of June, then we should agree on a date based on that.
If I can assist Mr. Bajmal, I think those dates are more easily referable once we set down or pencil in a date for the trial, and then we could work backwards on those pre-trial steps, which are the progress monitoring date, the trial bundles, reading lists, skeleton arguments, etc. So, Madam Registrar, we're in your hands as to when the court is best placed to list the trial, and then we could perhaps work backwards on the dates.
Yes. So what approximate dates do we have down for trial at the moment?
So I think we are okay. I understand that the trial has to be held within 6 months of the case management conference, so that would be somewhere in October or November. So we are currently okay for October.
Good, Mr. Benjamin.
I think if we try to bring it sooner, that would be better. So from our side, we would be available in like the second half of August or September.
The problem with September, Madam Registrar, is that I understand my client has a extradition hearing, so he will not be available on those dates. Perhaps late September or October might be best.
Okay. Obviously, the sooner the better. If we try and pencil this in for sometime in late September,
Yes.
which is the earliest available that the defendant's available, the defendant can come to trial and obviously attend and provide evidence if required. Then that's a little bit less than, actually, no, that would be exactly 6 months, even a bit longer than 6 months. So ideally, even if we can aim for mid-September.
That should be
So
fine.
Yep, so mid-September, if the parties can provide availability from mid-September, if there's any dates that we should definitely avoid, I don't expect there would be that many, hopefully, given that trial shouldn't be listed for that long. How long do you think trial is likely to be set down for?
Based on my learned friend's input that there's only going to be the witness evidence is filed, I don't think it will take more than 1 or 2 days.
I think 2 days. Yeah, 2 days should be sufficient.
Yeah, I was thinking probably about 2 days. So I'll ask the court clerk, Ms. Al-Gharib, if you wouldn't mind now liaising with the judicial coordinator just to find out availability of judges from mid-September. And then so now we have to work backwards for the pre-trial review and the progress monitoring date.
Yes, I mean, if it assists, Madam Registrar, we could probably work that out between ourselves once we figure out the date for the trial.
That would be very helpful, yes.
Yes.
I think if the parties can at least provide 3 mutual available dates for each of those 2 hearings, being the progress monitoring hearing and the pre-trial review, then we can cross-check that with the judge's availability and send you some dates on that basis. Now, with the skeletons and the bundles, we are adopting a hardline approach. 2 clear days is unfortunately not enough. We're also trying to sway away from simultaneous exchange of skeletons. So what we want is the claimant to submit the skeleton about, let's say, 6 days before the hearing. The defendant has 3 days before the hearing, unless Mr. Saniniaki has any major objections to that. And then e-bundles are filed no later than 3 days as well. So that means the defendant's got a tremendous amount of work in 3 days, but I suspect the defendant would obviously prepare some form of skeleton in advance. How do the parties feel about that?
I have no objection to proceed on this basis.
So just to clarify, Madam Registrar, so defendant's skeleton is supposed to be a sort of a reply to the claimant's skeleton?
Yeah, so we never really used to do this, but we've received feedback from judges recently. And look, I'm in your hands. If you think simultaneous exchange is more sensible, I'm happy to do that. For me, I find simultaneous exchanges for my hearings to be a lot more logical than a skeleton filed and a reply, on the simple basis that the skeleton shouldn't introduce any new evidence. It shouldn't introduce anything fresh. It should just be a summary of the submissions that are being made. So my view, in fact, is probably simultaneous is better, but I know some judges have a preference for response skeletons. But I think what I'll do is I'm probably going to make an executive decision in this situation and say for applications, perhaps responsive skeletons might be good where you don't have an affidavit, filed in response to a particular application. So you rely more or less on a skeleton but I think for trials it makes sense for simultaneous exchange. What do the parties think?
I fully agree with you, Madam Registrar. In fact, it's been our practice as well to file skeletons simultaneously, just so that there's no surprises later on for either side. In fact, even if you file a skeleton later on, there's nothing for the nothing stopping the claimant from saying that they try to reply to some new point. So that's just going to lead into further dispute. So I think simultaneous in this instance might be best.
Fantastic. So let's stick to simultaneous 5 days before the hearing, so 5 clear days before the trial, and that includes bundles. And we're saying 5 days because we're adopting that across the board for all of our cases now.
Noted, thank you.
Thank you. Is there anything else that's outstanding?
But no, I think for the CMC order, I think we've covered everything. So we can move to the case management, the case memorandum. Sorry.
Yes.
I'm just going to share the screen again. Okay, so again, so we have a tracked version here. I think it would be best to I will take you through the objections rather than going through each point, because so anything that I don't comment on now is considered accepted. Does that sound good?
That's fine, but Mr. Bajmal, the purpose of a case memorandum is to set the case management order. We don't really use it beyond a case management conference. So I'm very happy to go through it with you if it would assist the parties, but typically it's only used for the purposes of finalizing the case management order.
Yeah, I'm happy to speak to the issues as well, straight off.
So does it have the list of issues contained within it? Because typically I've seen that. Okay, fantastic. Because I usually request that to be in a document of its own, but that's fine. Let's go through that and then revise the list of issues as well. Thank you.
Thank you. Okay, so again, I'm just gonna go straight to where we object. So we have the list of issues here, and the first amendment that was about the deletion. That here I'm looking at paragraph 12(1). So the defendant here made deletions with regards to certain statements that were made within this paragraph, but we object to this deletion because these are points that are disputed in the case. I do understand that the claimant has taken a position that perhaps the type of the investment was not a discretionary investment mandate, and they're free to do so. However, as a matter of listing down what are the issues in the case, this is an issue that will need to be determined by the court, and therefore we believe that this wording should stay.
I mean, Madam Registrar, we have reasons for, for the deletion. I'm just wondering, given that obviously you also would not understand and be aware of the integrities of the case, can we just agree to a list of issues whereby the changes or the disagreed portions are shown by track changes and later on refined as we go into trial rather than debating it at this point?
What I would be more inclined to do is it is quite important for the parties to agree a list of issues ahead of trial, just so they can keep their eye on the prize during document production, witness testimony, and the like as the case progresses. So I don't mind if the parties say that we agree on these types of issues, but we don't agree on those, and make it quite clear in every witness statement, every submission, whatever the case is, that these are the agreed points and these are the disagreed points. But it will make it quite difficult to essentially stick to the issues at hand, because everyone will be swayed by the issues that they don't agree on, if that makes any sense. So if the parties want to try and have another go at this, I'm happy to sit with you separately in an informal meeting, perhaps in, say, a week's time, and flesh out what can stay and what can go, because really you ought to have a document that everyone sees eye to eye on, a list of issues that everyone sees eye to eye on, that I've checked, that you can then take forward throughout the conduct of the trial. And that's a practice that, again, we're trying to adopt.
If I may make a suggestion, so perhaps maybe if there are, you could give us a few more days for us to try to reach an agreement, and then if we don't, we can have a joint meeting and try to reach a conclusion of it.
Yeah, I'm okay with that. Yes.
Okay, I think that's the best way forward, and that way that would give me some time to read into the case and understand exactly what issues I see to be at hand. So in case you want me to intervene, I can then make a more informed decision at that stage. So yeah, I'm happy with that, Mr. Bajmal. Thank you.
Thank you. Okay, so these are the two main things that we needed to discuss for today. I'm happy to address any further questions.
Nothing from me. I guess all I would really hope for is a agreed, or rather a draft case management order to be submitted to the court by, say, 4 p.m. tomorrow, along with the 3 mutual dates for each of the pre-trial review and the progress monitoring date. And then the consent order dealing with the amendment application. And then let's say until 4 p.m. next Wednesday, the parties can obviously sit down and discuss a list of issues, and to the extent nothing's been agreed or something hasn't been agreed, then we can have a meeting on Thursday, next Thursday, or next Friday, to flesh out the list of issues and finalize a case memorandum.
Yes, that's agreed. Thank you.
Thank you very much.
Thank you.
Thank you for your time.
Thank you. Have a great day. Thank you. Bye-bye.